copy of that inquiry commission will certainly impede the investigation.
Right? If the report has been written, what investigation is there now? If the report, presumably, unless the government first writes the report and then investigates, is a different matter. But otherwise, the report is after the investigation, not before. So what is it going to be?
No, for further action. No.
You see, let's understand. Somebody has done a report that this person is guilty or not guilty. The government has to decide what action to take. Should we suspend him? Should we dismiss? How does that impede investigation? All the government is deciding is, should we suspend the man? Should we dismiss him? Should we file an FIR against him? Fine, they can take 1 year to do it. Otherwise, CVC, you know what is happening in CVC. Recommendations are lying for years together.
And as a matter of fact, that's future information. The information which is available there is asking for only the report. The report is available there and it is not exempted under any other provisions of 8. That has to be given.
But these inquiry commission reports, unless they are tabled in legislature, can they be?
See, that's a different issue because that attracts a different clause where if an inquiry committee has been set up by the legislature or by the parliament,
by the government.
No, see, the government sets up an inquiry committee. It will table it in the legislature, but that is not something that it is mandatorily required to do. See, unless it is a part of the terms of reference of the inquiry committee, that the inquiry committee will submit its report to the legislative assembly, or that this report will be tabled. Then it is a contempt of the legislative assembly or the parliament if you make it public. But this is also, in fact, in a recent case, this has been discussed in great detail in the CIC. The substance of that is not exempt. The report is exempt. You see, for example, you might quote data and statistics as a part of that. Now, you can't say that once a statistics has been quoted as a part of this report, it cannot be made public.
I think Mr. Singh in the Ramnath Mishra committee report on the minorities, the CIC allowed it because the government was taking a very, very long time in deciding whether to accept it and then go to the parliament or not. So, and already some people had managed to get copies through their private channels.
Yeah, there I think you have, and rightly so to my mind, push the box. But in general, the principle that can be applied is that if it's a terms of reference of the report are such that it would be presented to parliament, then ordinarily one should wait to make it public. Otherwise, the parliament will rightly say, what's the point of presenting?
Here I have one particular point. Now, the parliament have certain privileges, legislatures for that matter. Now, the report, I am not talking only about the inquiry report which is set up under the Inquiry Commission Inquiries Act. I am talking about any report which is supposed to be tabled in the parliament or in the legislature. If it is published before it is placed on the table of the House, then it becomes breach of privilege. Now, this is another area which one has to be very, very wary of before giving orders in this matter.
Under the Commission of Inquiry Act, these reports are supposed to be placed in the Parliament or legislature within 6 months. So therefore, that's what we said in our decision. If it is not placed within up to 6 months, you can claim this. After 6 months, if the government chooses not to present it at all, there is no breach of privilege of Parliament or legislature because the government has decided not to place it before the Parliament or legislature. Up to 6 months, this can be claimed. After 6 months, I don't think we can claim this.
My question is, can we claim that kind of immunity? The Commission can be claimed that kind of immunity? Whether the government has committed the breach of privilege or not, who are we to decide?
No. After 6 months, in my view, it does not apply. And that is what we said in the Ramnath Commission.
Anyway, this is an area which my own view is that because the General Act's philosophy is that you must err on the side of transparency. Wherever you get a loophole like that, you should err. But as you know, 8(1)(c) specifically says that information disclosure of which would cause a breach of privilege of Parliament or the state legislature is excluded. Now, you are talking about inquiries, Committee of Inquiries Act. There are also other inquiries done without invoking the Committee of Inquiries Act. And there the important thing is that what was the undertaking of the government? If the undertaking was that this would be placed in Parliament or legislature, then this clause would come. If they just want to place it in Parliament or legislature, that's their business. That has nothing to do with breach of Parliament.
Excuse me, in this case, I am from Kerala. In this case, there is a typical case which has come up in Kerala, where the Commission had ordered the to give the information from the Secretary Legislature regarding a speech made by a minister in the Assembly, from the floor of the Assembly. The public information officer, of course, gave the text of the speech, and subsequently the issue came up whether the videotaping of this speech should be given. The Secretary of the Legislature denied it, and the Commission gave an order that it should be given. And Commission took action to penalize the public information officer also. What happened was the legislature referred it to the Privileges Committee, and Privileges Committee summoned the Chief Information Commissioner and another commissioner in front of the committee, and there were 2 sessions, but the matter has not been finally disposed of by the Speaker. Matter is pending with the Speaker. Therefore,
I think we are all aware of this case, and my own view, I don't know, Colin, what you think or other people, is that this is absurd. I mean, the Legislative Assembly has no locus standi to do this. This is an act passed by Parliament. What the Legislative Assembly of Kerala is saying is that we are above the Parliament of India and we don't give a damn what act the Parliament passes.
Go to all the high courts.
No, that's further, but I'm just saying, I mean, because there's no judge of the High Court here, so there's no point to be rating
But
it.
even the High Court did not interfere. The matter was taken to the High Court. High Court refused to interfere.
Then I think you should have come to the Supreme Court. Because this is a terrible precedence, you see. If they get away with it, then every state assembly will say, well, look, we are above the law. And then if state assembly states, then high courts will say it, and then the army will say it, and Air Force. And finally, only the IAS officers will be left as part of the RTI. All right. Okay, shall we move to the next one? Okay, the next section that we are looking at is 8.1J. Now, 8.1J is personal information. I will just briefly read it out, and this is a very problematic in many ways because it also talks about, it says information which relates to personal information, the disclosure of which has no relationship to any public activity or interest. So now you've got not just personal information, but you've got a further qualification that even personal information can be given which has a relationship to any public interest or activity or interest, of which or which would cause unwarranted invasion of the privacy of the individual unless the CPIO or the state PIO or the appellate authority, as the case may be, satisfied that the larger public interest justifies the disclosure of such information. Now, this is a very, I think to my mind, a very badly drafted clause because it first talks about no relationship to any public activity, which means that if it has relationship to public activity, in any case it's no longer exempt. But then goes on to say, no, the CPIO and the SPIO or the appellate must decide whether it has anything. This is also the clause which then gets linked up to that specific thing which should be general, that provided that the information which cannot be denied, blah, blah, blah. For example, even in this version that Colin you've circulated, even in the version you've circulated, unfortunately this is formatted such. No, your version is in. This is the Andhra Pradesh RTI.
No, this printed book also gives it after a colon. So therefore, this proviso is a part of J and not the.
Yeah, which I think is wrong, and I think we should make sure that we don't propagate this. But so now,
Mr. Singh, I think you should procure a copy of the government notification in the government gazette. That is the.
Yeah,
that is the,
I have a copy of that, which actually gives it as fully formatted. So it doesn't show it that it's only under J. It gives the whole thing in that sense. Now, this is very problematic, as I said, for many reasons. One is, what is personal information? The definition here is which has no relationship to any public activity or interest. Is there any such thing? For example, I would argue that my health or the state of my health might not be of public interest, but the state of the health of the pilot who's flying my plane is of public interest. You want to know whether your pilots in the Air India are fit and healthy, or are they going to drop dead halfway through your flight. The state of my mind might not have much relevance, but the state of the mind of the Prime Minister has great relevance. You remember the case when the Chief of Army Staff suddenly dropped dead, one of the earlier Chiefs of Army Staffs, while playing golf. And it became a big scandal because apparently he had had a heart problem for many years, but had used his influence to repress that information. So hadn't got into a negative category where he would have never become a general. Now it's got serious, he died while playing golf, so it's alright, but suppose there was a war on, and suddenly in the middle of that he dropped dead, it could have had a lot of implications. So this is one part of the problem here, is that what is it that is in public interest? Second is therefore what causes unwarranted invasion of privacy, and this has been, I mean the ACRs for example have also been talked about like that, etc., etc. And then the third is that what makes the appellate satisfied that the disclosure is in public interest.
Have you finished?
Yeah.
Okay. No, the army has got a rule that in a particular regiment they would recruit people from certain categories with a certain height and certain physical attributes. Now, if somebody goes and asks for the physical attributes of that person, then it is an absolutely, unalterable primary eligibility condition for getting that job. So it is no longer a personal information. If I ask somebody gets in a job in a reserved category, and I ask, a citizen asks for the certificate of his, whether he is a scheduled caste or scheduled tribe, that is no longer a personal information. This knowledge might embarrass him, but we can't help it. So that can't be classified as personal information. We have always held that personal information is one which is beyond the eligibility criteria which entitles you to be to be in the government, or even for the class of people who are in the government, for them any information which is beyond the eligibility condition. Suppose graduation is the minimum qualification to get it. Somebody has got more qualification and he has submitted those certificates to the authority. If somebody asks that to please give the entire dossier of his personal educational qualification, probably apart from his degree, the remaining certificates could be denied because that is personal information, that is not part of his eligibility, and so on.
If I might just add one small thing, the place where it becomes very difficult and interesting is income tax returns. I mean, fiduciary we've already discussed, but are income tax returns personal or not? Many people have held that they are personal information. My argument is that, look, that tax is something you owe to the government. Now suppose I show I have no income and I'm paying no tax, or I'm paying a minimum, but I've got 4 imported cars and I'm living in a house with 10 air conditioners. The public has a right to know, okay, am I paying the tax which is reasonable? How come I've got all this? But generally the view has been so far, Shailesh, correct me if I'm wrong, but I think this is the general view that has come from commissions, etc., that income tax cannot be paid. Am I correct?
No, not mine.
No, not yours, but I'm saying in general because you look at it.
The decision is the majority decision is the CIC decision.
But it cannot be paid.
I have to give it.
It cannot be. So CIC says it cannot be given, right?
Yes.
So that makes it even more interesting, that because you talked of eligibility, I think it is an eligibility criteria of being out of the jail that I must pay income tax. And so I want to know which of these people who are not in jail